Peace to everyone. I promised I would get the video on the 25 pages for the opinion of the Supreme Court of Mvskoke Nation regarding the Freedmen. Newsflash. The MCN Citizenship Board just issued their own 24-page request for a rehearing. And they're citing a bunch of different cases. Anyhow, like I said before, this ain't over, okay? So this video I'm doing right now, I probably should have done like about a week and a half ago. I meant to have the 25-page commentary done about a week ago. And so I'm behind. I'm trying to catch up. So this is July 1st, 2015. Mvskoke News. Oh yeah, fair use and First Amendment. Okay. And just an FYI, I'm going to be reading this kind of verbatim. You see, I'm also going to be commenting. If you want to read the full edition, you can find it on Mvskoke News. I think it's .com. Is that what it is? MvskokeMedia.com. And, you know, they got their web address at the bottom. Appreciate that. The first constitutionally amended free press in Indian country. Cool. Well, anyhow, page 1, and then this shoots ahead to page 4, which is going to be a lot more than page 1, by the way. It's by Jared Moore, who, I'm not going to lie, it's pretty obvious where he's been standing on the Freedmen issue for a while now. Now, he doesn't come out and say, yes, I support the Freedmen becoming citizens, at least not that I'm aware of, but his attitude on the issue, it's pretty obvious where he stands. But he seems like a nice guy. He seems like he's trying to be fair and balanced on the different opinions on this issue, but it's obvious where he stands. So, to me, because I wasn't born yesterday. Anyhow, let's continue on here. So he's Jared Moore, the assignment editor. So there's editor's note: the following legal coverage contains word use and style that differs from Mvskoke Media and AP guidelines in order to present and best reflect the language used during oral arguments. I don't know exactly what was said in the courtroom because of that, okay? I am of the opinion that there's definitely some stuff that was left out, and I'll get into that as we move forward, okay? So this is in Okmulgee, Oklahoma. The Mvskoke Creek Nation Supreme Court live streamed oral arguments, and I wish I had seen that, by the way. Okay, in SC 2023-10 to their YouTube channel on 10th of June 2025. So due to an MCN Supreme Court order, reproductions of the oral argument were not allowed, and the video was removed from YouTube by the MCN Supreme Court shortly after. It says MCN-SC, just so you guys understand what that means. I'm sure you know. Mvskoke Creek Nation Supreme Court, all right? SC, so Supreme Court, 2023-10 is a challenge filed by the Mvskoke Creek Nation Citizenship Board of an MCN District Court decision. The MCN District Court reversed the MCN Citizenship Board decision denying Rhonda Grayson and Jeffrey Kennedy's MCN citizenship applications and order the board to reconsider them in accordance with Article 2 of the Treaty of 1866 between Mvskoke Creek Nation and the United States. And by the way, that was Judge Mauser who made the decision on the Freedmen's behalf, which Principal Chief David Hill issued a stay on that as the nation decided what to do next, basically. There was the was it James Jennings and as a special whatever. Anyway, so continuing on here, Tuesday's oral arguments saw Rhonda D. Luthi, no, sorry, not Rhonda, Graydon D. Luthi, R. Trent Shores, and Barrett L. Powers of Gable Gottwalls representing the MCN Citizenship Board. Luthi presented the arguments. Grayson and Kennedy were represented by Jana Knott and Demario Solomon Simmons, of course, with Knott representing arguments. Okay. So this is the MCN Citizenship Board arguments. Arguments began with Luthi outlining the main arguments put forth by the board. Just that statement right there is kind of an abridgment. Okay, there's obvious, it seems to me. So, just so you guys, moving forward, there's definitely some, as even stated by the editor's note, there's definitely some amending that was done to the original words spoken. Okay. So Luthi stated that there are 2 questions for the MCN SC to decide in the case. The first question, according to Luthi, was if the MCN District Court violated the nation's sovereign immunity when it held an evidentiary trial to review the Citizenship Board's administrative agency ruling on Grayson and Kennedy's citizenship applications. Luthi asserted that this violated MCN code provisions for review of administrative decisions and violated the nation's sovereign immunity. This is where we get into lawyer speak that I'm not completely fluent at. I'm going to be completely honest with you guys, okay? As we go through this, and as we look at the 25-page document, if I recall correct, because I got like 12 pages into it, there's a lot of lawyer speak involved. Court speak, it's literally its own language. Like, human beings don't speak this way unless they are lawyers and judges speaking in a courtroom. That's it. So part of what I just said in that paragraph, there's something I'm missing that I don't fully understand because I don't speak lawyer speak, okay? The second question Luthi argued was whether or not the MCN District Court decision should be overturned for invalidating the MCN constitutional provisions for citizenship. Luthi asserted that the Treaty of 1866 did give certain freedmen and their descendants the rights of MCN citizens, but the treaty did not include any words that guaranteed those rights in perpetuity. Luthi pointed out that nowhere in the treaty does the MCN give up any rights to determine its citizenship in the future. This is true. At this point, Chief Justice Andrew Adams III asked if Luthi's interpretation of the treaty provided any time frame for validity of the freedmen rights. Luthi responded that the treaty does not include any time frame. Luthi asserted that the treaty rights were not perpetual unless words such as forever are used in the treaty to describe them. Luthi, I'm a mixed blood. I'm 1/8. Do I have citizenship in perpetuity if they decide to say you have to be a quarter to be a citizen? I mean, they can kick the rest of us out as soon as even more casino money happens. That's what Seminole Nation of Florida did. That's why they have such small numbers. They have tons of descendants, I'm sure, but they don't have citizens, as many citizens, because you have to be X amount or more just to even be a citizen so you can get your per capita. Let's continue. Luthi referenced several treaties which all use the words forever, perpetuity, and for all time to describe treaty rights. Treaty rights. Am I slurring my speech here? Chief Justice Adams asked if there was any case law which Luthi could cite which affirms that without those words, a treaty becomes stale or moot. Luthi stated there were not, and that the board was not arguing that the treaty had become stale or moot. The board's argument was that since the treaty did not include language that affirmed the rights of perpetuity, under the retained rights doctrine, the MCN retained its sovereign right to determine its own citizenship. Which would mean that the 1979 Constitution, if the voting was done properly, we'll get into that, is completely valid. It means that the freedmen being removed from citizenship is valid. But we'll continue on. The retained or reserved rights doctrine is a legal principle which states that Native American tribes retain any rights not explicitly granted to a state or the United States in a treaty. Luthi detailed how the 1979 MCN Constitution was required by the Oklahoma Indian Welfare Act to be approved by the United States Department of the Interior before citizens could vote to enact it. Luthi affirmed that the Constitution was approved, specifically the citizenship requirement language. Justice Kathleen Supernaw asked if MCN members at the time had to approve the Constitution before it was sent to the Department of Interior for its approval. Luthi agreed that they did and asserted that all MCN citizens were eligible to vote on the 1979 Constitution, including the freedmen. So they were eligible to vote. okay, is what he's saying. Which, again, the issue is whether or not their votes were counted or not, or whether they all got to vote or not. I don't think my mom voted on this, okay? And it was roughly around that time that we started getting our own individual citizenship cards. She didn't have her own individual card till like 1987, okay? Like, my grandmother never had, so yeah, my mom didn't have hers till the 80s. My grandmother never had hers because she died in the 60s, and there were no individual cards back then, okay? My great-grandmother was a original Dawes Roll allottee, okay? So they were all going to the Indian clinic under their grandmother's roll number back in those days, okay? My mom remembers that. So that's how it was done, okay? My mom wasn't living in Creek Nation in 1979. I don't think she's ever been registered to vote. I'm pretty sure she's never been registered to vote in MCN elections. I have. That's because I was living in Oklahoma when Miss Golden, not Teresa, I believe it was Sandra, came over to my Aunt Arlene's house where I was staying and got me registered to vote. I appreciate that a lot. So, but yeah, my mom, her brother, I don't think they were voting in that election, and they had every right to citizenship. Does that mean that I don't know if it was in 78, 79, when it actually was that we got our own cards. It might have been after the Constitution was established, in which case they would have been considered already citizens, I guess, but without cards. My mom has cousins who consider themselves citizens and thought they can get the COVID money. Turns out they don't have their own tribal citizenship cards because their dad never got them for them because their dad died before those cards were being created. So they just assumed, oh, I'm a citizen, but not under the current standards of citizenship. So anyhow, so yeah, my mom didn't get to vote, just as a side note, okay? We're assuming, based upon what is saying here, that the Freedmen were eligible to vote. Okay. Luthi pointed to an opinion issued in 1941 by the U.S. Solicitor General and asserted that it also approved of the provisions in 1979 Constitution. Oh, this goes on to page 5 as well. Yeah. The Justice Supernaut asked if there was any documentation about how notice was given to all the Mvskoke Creek Nation members about the constitutional vote and how it was presented and advertised to the people. Luthi stated that he thought it was advertised, but did not have any record of it being so. I could believe that as being a legit truth. I don't know how true it is. I know that's certainly something that's going to be contested, but later in this page. But in any case, I'll have to ask my mom about that. Did she get notice living in California, or was it only to those living in the borders of the nation at the time? Okay, who were, I guess, before you had your own cards, were you able to be registered to vote? How did that work back then? I don't know. That's actually kind of what I want to know. Okay. Luthi pointed out that after the 1979 Constitution was enacted, there was no lawsuit brought challenging it and no complaint from the DOI about the electoral process used. I guess no lawsuit from the federal government. I'm assuming that's what he means. Okay. Obviously, the Freedmen have been suing us for decades, okay, regarding this. Luthi then proceeded to go through the history of the Grayson and Kennedy case, highlighting that the district court treated the case as active litigation instead of an administrative law review. Luthi asserted that the resulting evidentiary trial and decision invalidated the MCN constitutional provisions for citizenship. Luthi stated that this meant that the district court decision should be reviewed under a de novo standard of review. Oh, my arm's getting tired. Holding is weird. De novo review means that the lower court's decision on the matter under review will not be considered and that the court hearing the case will do so as if it is being heard for the first time. as if there's not going to be any bias from someone in the court, right? They say you got to treat it this way, but are they really treating it that way? Anyway. Chief Justice Adams asked if the standard of review was informed by Title VII, Section 4-111 sub B, whatever that is. Luthi suggested that since this was a constitutional matter, that code did not apply. Luthi stated that the de novo review applied to judicial cancellation of a constitutional embedded right to determine membership. Luthi asserted that the district court's decision could not be upheld unless it was determined to be required and inevitable. Again, there's portions of this, like I don't know what that Title VII, Section 4-110 sub B, there's a lot of stuff I don't really, like, I don't know. I'm not going to lie. I'm going to try to break this as much in layman's terms as I can. Let's see. Vice Chief Justice Richard LeBlanc asked why the language of the 1866 treaty that included the freedmen as citizens was not included in the 1979 Constitution. It's funny because the way that, knowing now how this turned out, I can see why they're asking certain questions the way that they're asking them. It's because they already planned on ruling in favor of the freedmen, I think. I don't know for sure. I can't say 100% for sure, but I think that's what happened. And so they're asking questions in a certain way, almost hardball questions. Not that they shouldn't, but I'm just saying. Let's continue. Luthi stated that he had no idea. He affirmed the language was not in the provisional constitution submitted to the voters before DOI approval and that the voters approved it without the language. Luthi reemphasized that the DOI and thus the United States, which was the counterparty of the 1866 treaty, had approved the 1979 Constitution. Okay, I think what he's saying here is that, so why wasn't the verbiage of the 1866 in regards to including the freedmen, why wasn't that in the 79 Constitution? Luthi is basically saying, no, I don't know why, for sure, technically, but it was not in the provisional, it wasn't in the version that the voters got when they said yes for the Constitution. So that's why it was not theirs, because it wasn't there, basically, and the people voted on what they voted on. Okay. That's what that means. As I take a double take on this here, okay? So, and since the U.S. government, the DOI approved it, then it's legit, basically, is kind of what it's saying here. Vice Chief Justice LeBlanc asked if Luthi would agree that the binding nature of the treaties is reinforced by the principle that the treaty rights are not terminated on statehood or other changes in government. Luthi agreed. Justice LeBlanc then asked why the 1866 treaty would not apply to the MCN requirements for citizenship. Luthi answered that it was because that was the decision of the people. He's saying that the people decided when they voted for the Constitution, which excluded the freedmen, it said you had to be by blood, that's what makes it legitimate. That's what he's saying. Okay. I can't really say much against that because the people didn't really have a vote on the 1866 treaty and how it was going to basically sell off half of our land to pay off the freedmen and to pay back the loyal Creeks for the losses, which still took almost 100 years for us who followed this guy right here on my shirt, okay, to get our stuff back, to get reimbursed for our losses. But hey, at least the freedmen got everything they wanted, and I'm glad they got freedom. I'm glad. I don't believe in slavery. Teresa Golden, I don't believe in slavery. I don't think that anyway, that's a different video. I might do a video on that. I'm getting some really crazy comments in the sections, but I don't want to pollute this with Teresa's, idiotic questions that I've already answered multiple times, by the way. Decision of the people. Luthi said that certain legal principles were at work in the 1979 Constitution. The first example he used was the MCN's existential right to define membership. He stated that the Constitution shouldn't be overruled in absence of clear indication to the contrary. His second example referred again to the retained or reserved rights doctrine, which states that the MCN retain all rights unless they are expressly given to the United States. Luthi reiterated that the Treaty of 1866 does not use language that gives a perpetual grant of citizenship to anyone. That is true. That means that if they wanted to say you have to be a quarter or more to be a citizen, that would exclude me and my son. I don't want that, obviously. But if enough of the people said, yes, we want to vote out all of our own children that have half the blood that we have because we married outside the tribe, and we decide that we want to give it all back to the full bloods and the half bloods and the quarter bloods, well then yeah, we can vote on that, and that would actually cut ourselves in the wrist, basically. And I don't want that, obviously, but I mean, you know, that could technically happen under this principle, okay? Under the 1866 treaty, okay? Luthi asked the court if they believe that a tribe has the inherent ability to change its membership requirements. He stated that he thought the answer had to be yes. Luthi pointed out that the MCN changed the eligibility requirements for holding elected office by requiring 1/4 blood quantum. See, if you're a quarter or more, you're considered what's called a full citizen. I'm a citizen. My son's a citizen. My mom's a full citizen. I am not a full citizen. Just look that up. Look that up, okay? Luthi pointed to other tribes that have increased their blood quantum requirements for membership. As I mentioned earlier, could be done with us. I hope it doesn't, but it could be done. Justice LeBlanc pointed out that there are tribal, state, and federal laws that don't have perpetuity language in them, to which Luthi agreed. Luthi stated that the issue was not whether the treaty had language that only granted freedmen citizenship rights for a specific time. Luthi then asserted that the freedmen had citizenship rights until MCN citizens exercised their rights to change the citizenship requirement by voting for the 1979 Constitution. Chief Justice Adams asked if the MCN had a governmental citizenship role based on the 1866 treaty before the vote on the 1979 Constitution. Luthi responded that they did, and that the 1867 MCN Constitution was silent as to membership requirements. I need to get a copy of the 1867 MCN Constitution. I know I've looked at it a little bit before, but it's been a while. Chief Justice Adams asked if it was accurate that the 1867 Constitution authorized tribal towns to elect representatives to the House of Kings and the House of Warriors. I see where this is going. And some of these tribal towns were freedmen towns, such as Arkansas-colored, North Fork-colored, and Canadian-colored tribal towns. Luthi stated that those towns were not identified by name in the 1867 Constitution. Chief Justice Adams asked if those towns were allowed to elect representatives under the Constitution. Luthi stated that those events happened. He's being like, oh yeah, it kind of happened. You know, I can see kind of why they're, he's kind of dragging his feet on answering that one, okay? Because technically that is true. These tribal towns did exist. They were then part of the nation and couldn't send representatives at that point. So, I gotta stop drinking that crap. Chief Justice Adams asked if there was evidence on record that Creek freedmen were allowed to vote in the 1979 vote to adopt the Constitution. Luthi stated that he thought there was. Now, that doesn't mean that he has any evidence that they did, okay? That's kind of the problem here, and I'll get into that on the other end of this as well, okay? Chief Justice Adams asked if there was if any had been presented to the court. Luthi stated that he was unaware whether any had or not. So there's no actual proof that, you know, the freedmen were allowed to vote on that Constitution. But there's also, I don't know, like it seems like there's a lot missing from that era. So I'd like to see more of the records if they're out there, okay? Chief Justice Adams, but also there's the issue, and I know Jared Moore covered this before, where he discusses whether or not, as long as like 1/3 of those who are eligible to vote, if they voted for it, for the Constitution, then that might have been considered valid. If it was like less than a third of the voters that were allowed to vote, something along those lines. But anyway, that's I don't have the specifics on that. That's just kind of what I vaguely recall from a previous video of Mvskoke Media of Jared Moore narrating. So okay, where was I at? Chief Justice Adams asked if Luthi would have the court assume that the freedmen were allowed to vote for the 1979 Constitution. Luthi said he thought that it was generally well known within the MCN that the freedmen did vote. I don't know if he has any proof, any affidavits to that effect. I'd like to see that. I'd like to have some type of backing for that statement, because I don't know if that's really accurate. But I don't know if it's inaccurate either. That's the problem. It's kind of like, maybe it's hearsay, maybe it's true, maybe it's not. I don't know. He thinks that it was generally well known within the MCN that the freedmen did vote. Luthi asked why, if it were the case that the freedmen were denied the right to vote, they had not filed for a lawsuit on the matter in 48 years. I think they did. That's the only part where I'm going to kind of like push back on Luthi, is that there's been multiple lawsuits against Mvskoke Nation. It's been in much more recent years. It's been more like, there's been attempts to get things going in the past. I don't know the exact timeline, but I know that I think it was 2018 or somewhere on that. When Chief James Floyd was the chief, he was one of the defendants. They weren't just suing, as Eli Grayson falsely claimed on his K-Bob video a year or so ago, when Judge Mauser ruled in favor of the freedmen. Okay, he was saying that, oh, it's only the citizenship with different departments, and it's that department that got sued. No, that's a lie. Even Demario Solomon Simmons admitted they were suing the nation. And if I look at that document on this case, Grayson Kennedy suing Chief James Floyd, I've seen the court documents. I believe it was 2018. I have to go back and double check, but I've seen the documents. It happened. They were defendants. Sorry, Eli, you know better. But then again, so does Luthi, I think. So I'm going to be fair and honest, okay? Chief Justice Adams pointed out that Luthi was asking the court to assume that the freedmen participated in the vote, and also that if they were disenfranchised, they would file suit. Luthi stated that he thought that such a suit would be inevitable. At this point, Luthi's time for argument had expired, and Jana Knott, representing Grayson Kennedy, began her argument. We're already almost 30 minutes in here. We're about halfway through this article. I'll try to go a little bit faster if I can. We'll see if I'm successful or not. Knott began by pointing out that the 1866 treaty had not been abrogated. That's a very important word in the course of this, which will be further expounded upon, as you'll see. Had not been abrogated and remains the supreme law of the land, which is like the broken record of the Creek Freedmen band. Supreme law of the land, supreme law of the land, supreme law of the land. And even Jared Moore is basically kind of stated that as well. Or he says he believes that treaties are the supreme law of the land. He didn't specifically state, as far as I remember, that the 1866 treaty was the supreme law of the land. But he said that treaties are. He believes treaties are. So, Knott stated that Article 2 of the treaty gives Creeks of African descent. Remember that. Creeks of African descent. Does it actually state that these are Creeks who happen to also be of African descent? Okay, that's very important, because there's a narrative, a false narrative being pushed by this side on this issue, okay? Creeks of African descent and their descendants all the rights and privileges of native citizens, and that the laws of the nation shall give equal protection to all such persons. Knott asserted that even though the Citizenship Board did not use the term abrogation in their arguments before the court or in their briefing, the case was about treaty abrogation. Not stated that each of the arguments put forth by the board was a form of implied abrogation. Not cited the Supreme Court decisions in McGirt versus Oklahoma, Minnesota versus Millie Lax Band of Chippewa Indians, and United States versus Dion, where the U.S. Supreme Court ruled that congressional treaty abrogation must be clear and unequivocal. It cannot be implied. Not pointed out that it made no difference if the 1979 Constitution was approved by the United States Bureau of Indian Affairs. Only Congress can abrogate a treaty. The BIA approval was a federal executive action. Not asserted that treaty rights do not and should not ebb and flow at the whims of the executive branch. Otherwise, treaty rights would be abrogated every time the administration changed. According to Nod, the U.S. Supreme Court decision in Minnesota versus Millie Lax Band of Chippewa Indians held that executive action, in that case, an executive order of the president, absent congressional authorization, could not serve as a basis for the termination of treaty rights. Congress must clearly express its intent to abrogate a treaty. Not stated that it made no difference that the BIA approval was required by the Oklahoma Indian Welfare Act, because any federal action impacting a treaty right is evaluated under the legal framework of abrogation. Not continued that in United States versus Dion, the U.S. Supreme Court found that the Bald Eagle Protection Act abrogated the Yankton Sioux Tribe's treaty rights to hunt for bald eagle and golden eagles. The legislative history of the act showed that Congress considered the importance of hunting the eagles to the Yankton Sioux Tribe religion and included provisions to issue religious hunting permits to tribal members. The U.S. Supreme Court saw this as congressional treaty abrogation. Not then compared the Dion decision to the Oklahoma Indian Welfare Act. Not stated that the Oklahoma Indian Welfare Act doesn't mention treaty rights or citizenship rights of any of the Oklahoma tribes. According to Knott, nothing in the language or legislative history of the act shows Congress considered any conflicts between the act and the Treaty of 1866. Knott asserted that the denial of citizenship to descendants of freedmen in the 1979 Constitution is a race-based exclusion that violates the treaty. Does it violate the treaty because it's race-based, or does it simply violate the treaty? Just a side question, right? Not stated that any constitutional provision that strips freedmen descendants of citizenship is void ab initio, regardless of BIA approval. Void ab initio is a legal term that means the action never had any legal effect. Again, that kind of nullifies our entire last 45 years, roughly, of MCN, 45 roughly years of MCN tribal history and government. Okay, if that is in fact true. So, that means we've had a de facto government this whole time, a de facto tribal, a national council, Supreme Court, principal chief, et cetera, but all that's null and void because of the freedmen not being citizens, because of this interpretation of the law. I don't know. I mean, just saying. I mean, there's a lot that we have to accept all of a sudden if this is correct. Okay, and I don't accept that personally, as you guys can tell. Not also pointed out that it is irrelevant if the freedmen were allowed to vote for the 1979 Constitution because treaties cannot be abrogated by unilateral tribal action. Not disputed the freedmen descendants were allowed to vote. So yeah, again, it's been disputed that they were allowed to vote. Now again, they can't prove that they were not allowed to vote. And supposedly there's notice given, but they don't know how exactly it was done. Pardon my French, this is a shit show. We don't know whether or not they got to vote or not. Whether or not they got to vote and how notification was given. It's assumed by one side that they were not only were allowed to vote, eligible, but they actually were notified somehow. And the other side saying, oh, we don't think they were allowed to vote at all. But nobody can really provide proof either way. That's the problem. So neither side wins on that one, in my opinion. I just think we have a lack of documentation. I think things were very backwoods at the time when it came to this issue. And like I said, my mom and my uncle never voted on this. And they were citizens of the tribe. Okay? So, just saying. So whether or not the freedmen actually voted might be less relevant than the fact that they were allowed to vote. The issue might then be what kind of notification, but even if it did exist, maybe it got lost a long time ago. Maybe when people burn their trash in their front yards in Oklahoma, because they do, or the backyards rather, whatever, that all records got lost. It just became yesterday's newspaper. I don't know. You would think that someone in the, someone would have made mention and maybe saved some documentation about this, but maybe not. I don't know. It's kind of weird, and neither side wins on that issue, in my opinion. So, not quoted the McGirt versus Oklahoma decision, stating that the power to abrogate a treaty belongs to Congress alone. Chief Justice Adams asked how Knott would address the Solicitor General opinion mentioned in the Citizenship Board's arguments. Knott replied that so they're kind of like, I don't know. I think they're being soft on the freedmen and being maybe a little bit hard on the nation. But Knott replied that the Solicitor General is an executive branch official, not Congress. Knott referred to the earlier analysis of Minnesota versus Mille Lacs ban of Chippewa Indians, which held that executive action absent congressional authorization could not abrogate a treaty. Knott addressed the arguments put forth by the Citizenship Board that the MCN had the sovereign right to determine its citizenship. She agreed that the nation has the right to determine its citizens, but stated that the argument relies on implied abrogation of the treaty. So here's what bothers me. Mr. Ron Graham in the past has stated that, oh, the Constitution's great, it's wonderful, da-da-da. But still, like, but 1866 is the supreme law of the land. Well, you can't have it both ways. Either it's a good Constitution and it's valid, or it's toilet paper. I'm sorry. Okay? I'm sorry. So we're getting double speak here from the freedmen a lot of the time. Okay? By the freedmen, I'm talking about the Freedmen band, the representatives. I'm not saying everyone of freedmen descent or whatever. I'm saying the people that are fighting this issue right now, there's a lot of double speak and there's a lot of pseudo history going on too. Okay? How can we have the right to determine our own citizens? How is that valid if any kind of abrogation is not valid? Any implied abrogation? I'm just saying, this is kind of the kind of stuff that comes out of their mouths. Really, it baffles me. It really does. Now, it doesn't baffle me. I see what's going on, but it bugs the crap out of me. Okay. It's like, oh, it's so wonderful and great, but you can't do without this and that. It's like, okay, yeah, but hold on a second. All right. Knott gives examples, specifically Santa Clara Pueblo versus Martinez, United States versus Wheeler, Marion versus Jicarilla Apache Tribe, and Iowa Mutual Insurance Company versus LaPlante. According to Knott, these are all cases where the U.S. Supreme Court ruled that tribal sovereign powers had been restrained or abridged by treaty or act of Congress. Knott asserted that the Treaty of 1866 clearly restricts the nation's sovereign rights to determine its citizenship as it relates to the Creeks of African descent and their descendants. Well, except it does say, as shall be permitted. Okay? Remember that. Knott pointed out that the Citizenship Board's arguments revolve around whether unilateral tribal action can abrogate a treaty provision. She asserted that it cannot. Congress is required to abrogate the treaty through legislation or subsequent agreement. Knott addressed the lack of language of perpetuity arguments put forth by the Citizenship Board. She referenced the analysis put forth by Cherokee Nation versus Nash, which found that the Cherokee Treaty of 1866 did not contain language that limited in duration or expired on any conditions the citizenship rights of freedmen included in the treaty. So they had their own freedmen. I think it was Chad Smith, Chief Chad Smith, that, was it Chad Smith or Chuck Smith? I think it's Chad Smith, kicked the freedmen out about a decade ago. I remember that became a big deal. So, so basically what he's trying to say is, well, the Cherokee Treaty, doesn't say it either, but now they're citizens, so, blah, 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 All right. Justice Superdahl asked how not reconcile the language in Article 2 of the treaty with Article 10, which states that the nation agrees to any future congressional acts that might modify citizens' rights in Article 2. Not reiterated that the language and legislative history of the Oklahoma Indian Welfare Act does not include any discussion of tribal treaty rights or citizenship. She referred the court again to the Dion case as an example of treaty abrogation. Not also pointed out that the McGirt decision ruled that the entire treaty of 1866 was still in effect and that it was not possible for either party of the treaty to accept one provision and deny the other. Not possible. Okay. So one party, the other, one party being Mvskoke Nation, the other party being the United States. Okay. That doesn't make any sense either. Because obviously representatives of the U.S. government, obviously Congress, could make changes. That's the United States. Okay. So either party, well, what do you mean by that exactly? Because it sounds like Creek Nation versus United States, these being the two parties in question. So obviously there could be changes done. So like I said, there's a lot of double speak going on here. Not addressed an earlier question from Justice LeBlanc concerning why the language of the 1866 treaty was not used in the 1979 Constitution. She stated that evidence was presented in the MCN District Court that Article 3 of the 1979 Constitution was passed because of racial motivation. And I agree with this. I agree that this is what happened, okay? Not just because it's being cited here, but because I've read it before, okay? Not quoted a statement from Principal Chief Claude Cox to the MCN National Council on October 29th, 1977. Not quoted Cox as saying, quote, "That's what we're fighting for, this blood quantum, trying to get back and let the people control. Because under the old Constitution, the 1867 Constitution, you've lost before you've ever started. There were 3 freedmen bands that would outnumber you today as citizens. So if we want to keep the Indian in control, we got to take a look at this thing and get us a constitution that will keep the Creek Indian in control," unquote. He's not wrong. I mean, I'm sorry. I don't think the tribe should be overrun by non-Indians. I think to be an Indian, you've got to have our blood. Okay, I agree with the principle here. I think that's, look, I mean, after this, you still had Indians by blood that looked black because they had Indian blood from the Dawes roll. Now, again, as I've always stated, and I'm going off on a side note here again, the video is already long enough as it is, but there are errors in the Dawes roll that need to be fixed. There are some $5 Indians that should be kicked out. There are some people mislabeled as freedmen who had Indian blood, who had a Mvskoke daddy, and because of that, they should have been Mvskoke by blood. They should have been listed as Creek by blood on that roll. They were not, some of them. Others were, usually if their moms were Creek. Okay? So there are some errors that could be addressed that I think need to be addressed before the issue of the freedmen becoming citizens even comes up. Okay? Like, we need to fix some of our requirements for citizenship by going back to earlier documents. Like, I mean, seriously, like, go back at least as far back as 1882 to prove that there's actual Indians in your bloodline, okay? But also to prove that there's not Indians. Because, there are definitely some freedmen, quote unquote, that actually are Indian by blood. But there's also a lot that are not. So, and that's the thing. So, moving forward, Justice LeBlanc replied that there were political implications in the 1979 Constitution to which Nott agreed. Nott also addressed, you got to keep the Indians in control of an Indian tribe. I'm sorry. We're not just some corporation that could be bought by somebody else and then sold to somebody else. We're a tribe. And yes, we're a race of people that shouldn't just be supplanted by everybody and anybody. That's colonization at its worst. And the freedmen are very much a part of that right now. I'm sorry. But this whole lawsuit that's been happening is forced colonization. And everyone talks about decolonizing your mind and accept the freedmen because of the promise we made, our ancestors made. It's like your ancestors didn't have diddly to do with this, most likely. There was a handful of people, one of which was a freedman named Cow Tom, or Cow Miko, as he was calling himself in the treaty. And the people really weren't in a position to vote on this issue at that time. The Civil War had just ended. Okay, let's be very real about this. Okay? So, yeah. This whole situation is forced colonization. That's actually really what I'm against. This is not a skin color issue at all. You have people that look like full-bloods that probably shouldn't be citizens of our tribe. Okay, that's a different issue. I've mentioned a little bit of that in the past as well. So, i.e., they had no Mvskoke ancestry. They got other tribal blood, not ours. But unless they're Yuchi, then they really, I don't know. Later video, okay? We can cover that in more detail later. If I already have covered it, but, we can cover it a little bit differently next time. Let me get back here. Not also addressed a question by Chief Justice Adams about the 1867 Constitution. Not asserted that at the 1866 treaty negotiations, the United States made it clear that freedmen participation in the government was a prerequisite for the reservation provisions in the treaty. A prerequisite. I don't know if that's really quite the accurate statement to make. Prerequisite. Yeah, the 1867 Constitution was the affirmation of the treaty requirements, with freedmen being represented in the Creek government, serving in both House of Kings and House of Warriors. Chief Justice Adams asked what Knott's response to the Citizenship Board argument that the MCN District Court did not have the authority to issue its decision. Knott replied that the sovereign arguments made by the board in relation to the District Court decision were a distraction from the real issue in the case, whether the 1866 treaty had been abrogated. So he's focusing abrogated. Okay. Chief Justice Adams clarified that he was interested in hearing Knott's position on the argument that the board put forth. The district court should not have had an evidentiary hearing in the matter. Knott stated that she had two responses. She asserted that the nation waiving its sovereign immunity for appeals of the Citizenship Board's decisions. She stated that after the case, let me reread that paragraph. My mind's kind of long day at work, but anyway. Chief Justice Adams clarified that he was interested in hearing Knott's position on the argument that the board put forth that the district court should not have had an evidentiary hearing in the matter. Okay, sounds a little bit better in my mind. Knott stated she had two responses. She asserted that the nation waived its sovereign immunity for appeals of the Citizenship Board decisions. She stated that after the case had gone a year without being assigned to a judge, Grayson and Kennedy filed a motion for the MCN Supreme Court to assume its original jurisdiction, at which point the board filed a motion to dismiss, which requested that the board be afforded an opportunity to engage in the exercise of discovery and build a thorough record on all relevant facts and legal claims. According to Knott, this board requested for information that fell outside of the administrative record, necessitated an evidentiary hearing. Knott pointed out that whether the MCN Supreme Court declined jurisdiction, it agreed that the court would greatly benefit from an assembling of a complete record before the district court. Knott detailed that since the Citizenship Board requested the discovery process, the board could not now claim that the district court was in error in conducting it. Knott stated that the MCN Supreme Court ruled that the district court proceeding was an error. The MCN Supreme Court should still rule on the constitutional question at hand because it is the only court that can do so. Knott closed her arguments by stating that if the MCN holds that the Article 2 of the 1866 treaty remains in full force and effect and the treaty is still the supreme law of the land, it must affirm the lower court's decision. Okay. Man, it's a lot. Okay, so this is the Citizenship Board's rebuttal. Luthi stated that the board is not arguing that the treaty was abrogated, and in fact, the board claims the treaty is in effect. Justice Monty Deer asked if the U.S. Supreme Court could make a decision on whether the 1866 treaty had ever been abrogated by the tribe. Luthi stated that was not his point, continuing that the tribe's right to determine its citizenship is an existential right, and that if that right is to be canceled, it needs to be clear that it has to be canceled. Okay. Luthi's second point went back to the retained rights doctrine. Luthi stated that unless the MCN expressly gave a right to the United States in the treaty, MCN retains that right. Luthi's third point revolved around the language in the treaty. He stated that the language of this treaty did not give the freedmen special rights. It gave them the same rights as native citizens. It's funny that that's mentioned by Luthi, because Eli Grayson and others are saying, well, the only group of people that are guaranteed rights forever in the treaty are the freedmen. So Luthi's saying that's not the case, that they're not given special rights. They're given equal rights, or the same rights as native citizens. Luthi asserted that the treaty did not give anyone, including native citizens, rights to citizenship and perpetuity. That is true. Luthi also asserted that the treaty did not say that the MCN was giving up the right to determine through its election who its citizens are. Chief Justice Adams agreed with Luthi that the tribes have the right to pass their own laws and be bound by them. Chief Justice Adams pointed out that under MCN Title 27, Section 1-101, the authority comes from MCN sovereignty and also the treaties and agreements between MCN and the United States, including but not limited to the Treaty of 1866. Chief Justice Adams also pointed out that MCN Title 27, Section 1-103 states that in all cases, the MCN courts shall apply the Constitution and duly enacted laws of the MCN as well as the common law of the Mvskoke people as established by custom and usage. And the treaties and agreements between MCN and the United States. Chief Justice Adams also pointed out that the U.S. Constitution also has language concerning treaties being controlling, and asked Luthi if he agreed that the U.S. Constitution might be applicable in this situation. Luthi stated that the U.S. Constitution, as it has been applied to Indian tribes, would apply here. The Citizenship Board's time for rebuttal had expired at this point, but Chief Justice Adams had one final question. He asked if Luthi would cite any precedent or language in the treaty that would affirm the notion put forth of a sunset provision for portions of the treaty. Luthi stated that the board was not arguing that there was a sunset provision. I'm not sure what a sunset provision is. Anyway, he restated his argument that the treaty is silent on the principal issue, and since it is silent and doesn't use words of perpetuity or give up the right to define membership in the future, under the retained rights doctrine of the Constitution was proper. Luthi closed stating that ambiguity is construed in favor of the tribe in treaty determinations. Justice LeBlanc asked why the 1860s treaty is not the law of the land if it had not been abrogated. So again, they're kind of hardballing the tribe a little. I'm sorry, but it just seems that way. Luthi responded that the Treaty of 1866 is not abrogated by the Constitution of 1979. Justice LeBlanc asked if the 1979 Constitution had the same effect as the abrogation of the treaty. Justice LeBlanc asked if the provisions of the 1866 treaty were still applicable today. Luthi stated they are applicable, but included that the retained rights was the right to change the membership requirements. Luthi pointed out that the Constitution's citizenship provisions could keep a full-blooded Creek from attaining citizenship if their ancestors were not on the Dawes roll. This, unfortunately, is true. Okay? Justice Deer asked if it was true or false that... so that does mean that it's not totally racially motivated. We're sticking strictly to the requirements of the Dawes roll. Get that by blood ancestors on the Dawes roll that are alive at the time of the Dawes roll. Okay. Justice Deer asked if it was true or false that under Article 3, Section 2 of the United States Constitution, the U.S. Supreme Court had legal jurisdiction between native nations and the United States. Luthi affirmed that it was true. Justice Deer asked when the Supreme Court ever made a decision regarding the case. Luthi stated it has not. Justice Deer asked if it has a right to. Luthi affirmed that there is an actual case in controversy that goes to the system and certiorari is granted, then yes. I don't know what that term is. Again, legal lingo, Latin. Justice Deere then asked if that was McGirt versus Oklahoma. Luthi disagreed and stated that McGirt did not involve the issues in this case. Justice Deere stated that his problem all along has been that if the United States entered this treaty with the Creek Nation, when does the United States get input on the discussions had in this case? Luthi responded that he could offer some examples. Justice Deere continued that he had read a case concerning a tribal nation in South Dakota versus the United States. He stated that the tribe was upset that the land had been given back to non-native people, but the U.S. Supreme Court decided that the land could not be given back, but instead compensated the tribe monetarily. Justice Deere stated that in this case, the United States had input on the decision, but in this case, it had none. Luthi stated there are all kinds of ways that the case could get to the United States Supreme Court. He said that the United States could bring suit, which it hasn't. He pointed out that the DOI could get involved as they have with other tribes, which Luthi also said hasn't happened. I know that Eli Grayson wants to see that happen. Anyway, Justice Deere asked if those things can happen, then Luthi affirmed they could. Here is Grayson McKinney rebuttal. So I'm almost done here. Okay. Well, with the reading part anyway. I'll try to keep this brief if I can. Not address Justice Deere directly, stating that the United States can have a voice on this particular issue if Congress decides to abrogate this provision of the treaty, which she attested has not happened. Not reiterated that the treaty, including Article 2, remains the law of the land, supreme law of the land. Okay. I mean, I hear that term like it's like from a worship service, like it's a hymn. I mean, it's like it goes on forever and ever. Chief Justice Adams asked Knott's response to the retained rights doctrine argument. Knott cited Roth versus Birney as precedent, showing that tribal sovereign rights can be qualified by acts of Congress and treaties. She stated that Congress alone has the power to say the treaty is no longer in force on this citizenship issue. Knott attested that this has not happened. Knott pointed out that the U.S. Supreme Court did not include the MCN Constitution in its analysis. On the McGirt case, it only considered the 1866 treaty. Knott also pointed out that Chief Justice Adams was correct in his observations that the 1866 treaty was incorporated into fundamental MCN law and that MCN Supreme Court must apply. That the MCN Supreme Court must apply. Knott stated that any constitutional provision in conflict with the treaty must yield. Yeah, but would that make the whole Constitution invalid at that point? Because I'm not mistaken, I'll have to double check the dates, but I think it was all ratified at the same time. I mean, you go back to like 1970, what was it? 1977, Claude Cox. We read this earlier. I mean, they were planning this stuff before the 79 Constitution actually got ratified, okay? But if I'm not mistaken, it all came out at the same time. So what? Portions of it must yield? Anyway, I disagree. I think that would invalidate the whole Constitution. So, in her closing statement, Knott pointed out that the 1866 treaty listed the Freedmen as, quote, Creeks of African descent, affirming that they were always Creeks. Bullshit. That is not the case. There's too much of this false history going around, and now it's in the court documents. Okay? It's like Demario Solomon Simmons saying that, oh yeah, we were, our ancestors our Black Creek ancestors were enslaved by their basically red brothers so they could be more like the white plantation owners. It's like, no, bro, your ancestors were always African slaves before they came to the United States. Before there was the United States, they were African slaves. They were not Black Creeks, okay? That's a load of crap. Okay, and I'm tired of this fiction being put forward as if it's fact, because it's not. Okay? I mean, look at the documents. It keeps mentioning that they're of African descent. They're African descent. That's what's in the actual documents. Not this, they were always Black and they were always Creek. Affirming they were always Creeks? That's a lie. Not clarified that this was evidence that the traditional values of the Creek Nation never equated citizenship with physical appearance, blood quantum, or race. Yeah, except that your clan and your tribal town was matrilineal. You inherited your citizenship primarily through your mother. Your relationship to the tribe had to do with the clans you were directly related to on your mom and your dad's side, particularly your mom's side. So if your daddy was white, then your mom was basically the only, and of course, either way, you belonged to your mother's clan and tribal town. That's the way it was. And you look back at the legends of our people, and the clans got created at some point in the beginning when the fog was blown away by the wind, and the first to see the wind blow it away became the Wind Clan, and then all the other groups that had grabbed hold of each other, sworn eternal brotherhood to each other, had when these groups saw a certain animal, oh, there's a bear, oh, we're the Bear Clan, oh, there's a wolf, we're the Wolf Clan. And this is a group of Indians way back in the day, prior to Columbus, and this is our ancestry according to the legends, okay? And so race is going to be relevant by implication, implied abrogation, right? Anyway, sorry, I just had to take a jab at that. The justices had no further questions for naught. With closing arguments, the case was submitted with the court. Now, here we are an hour into this video. I'm just reading stuff that was done in court. They had limited time to present the stuff. I mean, this is a hearing. This should have taken all day. Did it? Was there a lot more that was in this hearing that I don't think it was all, I don't think it was a whole day, but I mean, I didn't see the YouTube recording of it. I'd love to see it. I'd sit down and watch the whole thing right now. Right now. Okay? This is a case that requires a lot more than what was just said here in this article, and apparently in the courtroom at that time. So unless this is a heavily edited, heavily redacted abridgment of what was said, and I don't think that's the case entirely. There's been some changes though. I don't know. If anybody here watched the entire thing, please let me know. If you have a link somewhere of some pirated copy of this, please send it to me. I would love to see it. Regardless of what the Supreme Court wants us to see or not. Because right now, I kind of don't care as much. I mean, send me the pirated copy of it. I don't care. Okay, I want to see it. Particularly if it's different than this. If there's like a lot that's different, or there's a lot more that isn't written down here, I want it. Okay? I'm just saying, man, because I believe in free speech. And I'm sorry, I feel like the court systems nowadays, in general, not just the tribal court systems, but the American court systems, it's like it heavily redacts a lot of things. And that's why you can't record it, because the court wants to have its official story very, very clear and cut and nice and tidy, even though that's not what happened in the courtroom, essentially. That's what it seems to be. So they're going to edit the notes if they have to, strike this from the record, strike that from the record, blah, blah, blah. Don't disregard what this person said, because don't let that affect your opinion, even though it does, because you're on the jury. And you just saw it happen in the courtroom, right? That's the problem I have with the court system. I think that there needs to be a little bit more freedom of speech to show us what actually happened, okay? And I believe in the freedom of the press. And I believe that applies to courtrooms as well. Okay? So, just saying. You got a bootleg copy, send it to me. I don't care. I want to see it. Slap me in the wrist later on. Sorry. Slap me in the wrist. Because I want to see what was actually happening in the courtroom that day. All right, but let me change the topic for a second from that. Yeah, this definitely should have been a much longer hearing than it was. It was shortened for a reason. I think the justice has already decided what their decision was going to be, but they were letting this play out in the courtroom to placate us, to placate both sides, but they already decided what they're going to do. Now, and I should probably get into this in my next video, or the next one might be a 2 or 3 parter, because I'll be reading 25 pages. But those 25 pages are actually not as long as you think. But it's probably going to be a 2-parter when I read the entire opinion of the Supreme Court on the ruling in favor of the Freedmen. But then I'm also going to print out the 24-page copy from the Citizenship Board, and they're now doing a, because they're now going to be doing a rehearing, or they're applying for a rehearing, which I believe they should get. If they get denied that, then you know what's going on. Okay? You know what's going on. But I do want to say, though, that, again, I don't know if anyone, before I give names again, anyone on the, any of the Supreme Court justices had pressure or whatever was going on to rule in favor of the Freedmen. But I wouldn't be surprised. But I will say that my reason for being against this form of colonization is because I believe that we have a right to decide our laws. And you're going to have people on the Freedmen side saying, you see, here's what you said a year ago, James, and look what happened. It's like, yeah, well, I don't consider the Supreme Court to be the people. This is something we need to vote on as a people. If we want to do only right way to do this is to have a constitutional amendment proposed, and then we vote on it. That's the only right way. And if the people decided they want the Freedmen in, I'd just say, okay, well, I can't fight the will of the people at that point. They're citizens now by right. We'll see what happens after this. That would pretty much be my response. Right now, the way it's set up is that because the Supreme Court ruled in their favor, well, give an inch, they take a mile. And now they want to sue us for reparations. Okay? Now, again, my proposal is this. If there was an amendment proposed, there have to be sort of a no harm, no foul cause where we don't have to pay reparations. You want to be a citizen and the people decide that you can be a citizen, then you can become a citizen, but you can't sue us for reparations for that 40 plus years of not being citizens. I'm sorry. It's got to end at some point. It's got to end. Okay, and the people, the real Mvskoke people, need to decide this. And as I covered in a previous video, when I overviewed the Mvskoke Creek Indian Freedmen Band's website, which is really not a bad website, it has a lot of information, and it provided me with some bullets against them. Okay, it gave me a bit of gunpowder against them because, it's obvious that in the late 1800s, yes, you had freedmen inside the tribal government, but it was also obvious that they did not consider themselves Indians. That Indians were considered Indians and the freedmen were considered freedmen. They were Creek citizens, but they were not Indians. They were not Indians, okay? And it's pretty obvious. Go back and watch that video of mine. So you really got to check that out, okay? Anyway, an hour and 8 minutes and 27 seconds. This is the longest video I've done, but I really thought it was important to read this to you guys because I'm obviously throwing in my opinions. I'm sidetracking from this a little bit. Now imagine if I didn't sidetrack at all. If I just read you this whole thing and that's it, that the video would be half the size. Again, like a 30-minute video. 30-minute hearing? Is this really a 30-minute hearing? I don't think so, man. I think this is a much bigger deal than that. It deserves more time. And it's obvious that their time was made to be limited. Okay? So, that just seems suspicious to me. Let me know what you think in the comment section below. To all you haters out there, I make no apologies for my opinions. You have a right to yours. I have a right to mine. I don't hate anyone based off of race or skin color or any of that. None of that's an issue for me. It's a by blood issue. You're Indian if you got our blood. It doesn't matter what you look like. I mean that. And that's a very not racist thing to say, by the way. So, also, again, I'm just going to say this right now, again, addressing Teresa Golden. I don't see how me disliking the Treaty of 1866 and being okay with the 79 Constitution automatically retroactively means that I want slavery, because I've never stated that. Okay? Besides, the 13th and 14th Amendments happened, the Emancipation Proclamation happened, and then the Snyder Act of 1924 happened, which means that we are all citizens of the United States if we're born in the territorial United States. That's before the freedmen were kicked out of the tribe, which means that they automatically became U.S. citizens if they weren't already at that point. And yeah, we can't retroactively, like, we're not going to be able to retroactively, like, make them our slaves again. Like, I mean, I don't know I don't know where that's coming from. That makes no sense. Okay, please use better. If you got the brain cells to figure it out, go look up the 13th and 14th Amendments, look up the Emancipation Proclamation, look up the Snyder Act of 1924, read the text yourself, and go from there, okay? That's it. Anyway, thank you all for watching. I apologize for the lengthiness of this video, but we got a couple more long ones coming, I think. So I appreciate your patience. For those of you who might be waiting for me to come out with more material on this, because I've been meaning to do this for, like, you know, like I said, like week and a half, this video was supposed to be put out there. So week and a half ago, sorry. Brain's on, I'm not running on all 8 cylinders. I'm running on 6 cylinders right now. Okay. So long day at work, food coma, probably a little bit of sugar coma from this wonderful drink I shouldn't be touching. All right. Anyway, but for watching. And hope you're all having a wonderful day. Even yes, Teresa Golden, you too. Have a blessed day, Teresa. Have a blessed day. Okay, to all you haters out there that think I'm an evil racist and who think that the tribe needs to be punished endlessly for whatever. I wish you all well. I mean that. I want you guys to have good lives. For those of you who have threatened me on social media over this issue, I wish you well. Just don't come near me with any kind of harm. That's all I got to say about that. And until next time, Adam Chi Chatlis.